Okay. So today we're continuing our discussion about Aboriginal rights by looking at how to define Aboriginal rights. You'll remember in the Sparrow case, when the right to fish for food, social and ceremonial purposes was put forward, that the Crown didn't really contest the fact that the Musqueam relied upon the fish for these purposes, so therefore there was no need to be able to work out a test for the definition of Aboriginal rights. But at the beginning of the decision, you're reminded of the Sparrow case, and if you look at paragraph 2 of Vanderpeet, you'll see the 4 stages that the court wants us to go through, the framework for proving Aboriginal rights. And you'll note that there's shifting burdens of proof that occur at each one of these stages. So for instance, the first part of the test is that the court must determine whether an Aboriginal person is pursuing an activity that can be defined as an Aboriginal right. And Aboriginal peoples have the burden of proof at that first stage of showing that what they're doing is pursuant to an Aboriginal right. That's part 1, defining the Aboriginal right, introducing the evidence of the activity and how it connects to an Aboriginal right. And the court is going to give us more guidance today as we read through Vanderpeet about what Aboriginal applicants would need to do. The second part of the test is then the court must determine whether or not that right has been extinguished. And this is up to the Crown to be able to put in evidence to show that there has been extinguishment. And you'll remember that the Crown has a high standard. They have to show clear and plainly that their intent was to distinguish the Aboriginal right. So first Aboriginal peoples have to prove the right, then the Crown has the opportunity to prove that it was extinguished. Then the burden shifts back to the Aboriginal people if it's not been extinguished, and they can, that is the Aboriginal peoples can argue that the right has been prima facie infringed by showing that they were denied the preferred means of exercising the right, or that the Crown's regulation is unreasonable, or that it causes undue hardship. And if the Aboriginal group is able to demonstrate this kind of prima facie infringement on any one of those grounds, then the burden shifts back to the Crown, and the Crown has an opportunity to justify that infringement. And it has to introduce 2 pieces of evidence to meet that burden, which is, first of all, that there's a valid legislative objective that the Crown is working in accordance with. And secondly, that the honor of the Crown is being upheld in the pursuance of that objective. So those are the 4 stages of the proof of Aboriginal title and its infringement. Now, today what we're going to be focusing on is the first and the 4th part of this test, because we're going to get from Vanderpeet more information about what the standard is for proving Aboriginal rights. And then in the Gladstone excerpt and the Delgamuukw excerpt, there's more information about what the Crown needs to do to show that the right is justified. The infringement of the right is justified. And what we're going to see is that the courts are going to give the Crown more grounds to pursue valid legislative objectives. Out of the Sparrow case, a valid legislative objective is conservation. We're going to see more grounds added that can be validly pursued. The court did say in Sparrow that you couldn't justify a law on the basis of the broader public interest. We're going to see an erosion of that principle in Gladstone, and then in Delgamuukw as well. And then secondly, what the Crown needs to do to show that its infringing this right in a way that upholds the honor of the Crown, we're also going to get more information about that. So paragraph 2 is a really important part of the Vanderpeet decision because it gives you the architecture for building the house or extinguishing the house or infringing the house of Aboriginal rights. And so what we have is this kind of framework that the court's going to follow as we discuss this case today, as we follow these issues more particularly. We're going to obviously talk about the facts and the issue that arises from those facts, but then there's going to be 3 sections of this decision that talk about the lens that the court must look through in receiving Aboriginal rights cases, ideas about liberalism, canons of construction, and the purpose of Section 35.1. So this calibrates the evidence to a standard that they can then test Aboriginal rights by. Then there's a test dealing with Aboriginal rights, integral to distinctive culture test, and then 10 factors that the court considers in defining Aboriginal rights in accordance with this test. And you can see the paragraphs where the court deals with this in the decision. And then finally, we'll get to application. And then once we deal with the Vanderpeet case, we'll look at Gladstone and Galgamook to further fill out the part that's missing here, which is what is the standards for justification that the federal government has to meet if it's going to infringe an Aboriginal right. So the facts here take us into the Stolo homelands. The Stolo are a Hulkaminam speaking group which live along the Fraser River around from Langley to Chilliwack, up to Hope, to Yale. Stolo, I understand, in Hulkaminam means Big River. So they're the people of the Big River. Incidentally, the Hulkaminam speaking people extend over into the Cowichan Valley area. And it's the same, by and large, language, same kinship associations. So this Cowichan peoples, along with the Stolo and Musqueam and other peoples, would go to the fishing sites here every year as the fish were returning. Now this is a storied land, as we talked about both with Anishinaabe and Cree and looking at their creation stories last day when we talked about the sparrow case. We understood that the salmon were a race of beings that came into the territory. And in fact, there's a story that's told about mink and beaver being playful with one another and also being playful with the salmon people. And one time as the salmon people ran into the mouth of the Fraser River, beaver and mink decided, as they saw the little ones, the little salmon, playing, that they wanted to hide the baby salmon from the adults. And so mink caused a distraction amongst the salmon, and as the salmon were watching mink, beaver went over and got one of their babies and started swimming with that baby upriver. And as the beaver was swimming upriver, what would happen is little pieces of the clothing of that baby salmon were left behind. And as they swam up the river after that fashion, they were eventually gone for quite some time, and the adult salmon recognized that their child was gone. And so they started searching, and as they searched, they saw the little pieces of clothing that were strewn as you work your way up the river. And so the salmon started working their way up the river. And when they got to these larger places up the river, they eventually discovered mink and beaver, and the child was fine and happy, and the child was back with the adults, and the salmon on that journey recognized the goodness of that place, and so they decided to return each year. The Stolo people, then when the fish start running, remember these stories, and they have what's called a first salmon ceremony, where you would have thousands of people gather as the first one is taken out, and everyone honors that return, and everyone's given a morsel of that salmon to share amongst the thousands of people that could be gathered there. This story is retold as people put on beautiful blankets and wear amazing salmon masks and dance and sing and tell the story about their obligation to the salmon. And in telling that story, there are standards for judgment that are created amongst the Stolo people about how they should think about and relate to the salmon. There's principles of conservation that are discussed in that story to ensure that there's this kind of continual return. It's not something that Western law might recognize necessarily as conservation principles, but it certainly is the case that the Stolo and other groups up and down the river had their laws to ensure respect for the fish and also to ensure respect for the other peoples that were living up and down the valley like this. This period of time, I'm not sure if it was before or after, eventually resulted in a great deluge, like we talked about in the Anishinaabe example, where there was a great flood that took place across the land. And in this flood, many people received guidance from the spirits around them to prepare for this flood. And so they made giant canoes, and they made big, long cedar ropes. And they tied these canoes to prominent boulders, rocks, at the tops of many mountains. And so, for instance, in the Cowichan Valley area, the same Hulkaminam people, one of those figures tied that canoe by a rope to a rock that's on the top of Mount Prevost. And you can still see that big boulder there. The world was flooded, and the only way they escaped that flood was by being able to float at the end of that rope. I also believe Mount Newton, here on the Saanich Peninsula, was a similar type of site for people escaping the refuge of the flood. When I taught at the University of British Columbia Law School, Sonny McAllisey, who since received an honorary doctorate of laws here from the University of Victoria, told the story about these floods as well, and told the story about where they tied up their canoes to be able to escape that deluge. As a part of that story, I was interested to hear that the ladybug played an important role in helping the people know what to do once the flood waters had receded. And the people that were in the canoe weren't wont to pay attention to something so lowly and small as a ladybug and receiving guidance as to how they should act in the world. But through that ladybug and paying attention to that ladybug, they learned what they needed to do in order to rebuild after that. And so there's songs that the ladybug passed on that I understand are still sung amongst the Stolo people that, again, talk about principles of management and relationship and reconciliation between the different parts of the world in that territory. I find it interesting that we've had a story about a muskrat and a mole and a ladybug, and the need to pay attention to not necessarily always those that are on the top of the hierarchy in figuring out legal answers to questions, but also looking much further and beyond. As a part of their place in this territory, here on Vancouver Island, over the Malahat, up the Fraser River, there's a group of initial spirits that populated the world as beings. They're called those who fell from the sky. And on the Halkomenum side, with the Cowichan, they're talked about being 12 different of those that fell from the sky. And they, as they went from place to place, helped to populate this world and give lessons about how to live properly in these territories. And these lessons often were embedded and embodied and physically represented in the earth. One of these, some say it's the ancestor of those who fell from the sky. I've sometimes heard that it's those who fell from the sky is a being named Hals. And this being was a transformer being. And as the Hals would walk the earth, he would reward good behavior and punish bad behavior. And so what you get is many rock features on the land that actually help the people. They actually regarded as ancestors. Once upon a time, that was, their great grandmother or grandfather, and that person did something either good and was rewarded, and therefore, was embodied in this rock in a particular way, or did something not so good and is embodied in another rock in another way. In other words, the law, the cases, are literally, again, written on the earth. The legal archive, the text, is actually found in reading those stories. And so you can get tours of the Cowichan Valley, you can get tours of the Fraser Valley that point out to you where these stone stelae reside. Now here's a story that's taken from the area that this case is a part of, which is around the Chilliwack area here. I'm just going to read it. It says, "A long time in the past, the world was not quite right. Humans and animals could take each other's form and communicate with each other. Into this world came owls, or transformers, the 3 sons and 1 daughter of red-headed woodpecker and black bear, who lived in the mountains at the head of Harrison Lake. The 4 children, who were all black bears, began their journey through what is now Harrison Lake and the Fraser Canyon and the Fraser Valley. As owls traveled, they made many transformations, including turning people who behaved badly to stone and turning people who behaved well into useful natural resources, such as cedar trees, sturgeon, and beaver. These transformed entities are the ancestors of today's Stolo people. The transformers did more than transform people. They generally made the human and natural world a better place as they went. After traveling from sunrise in the Fraser Canyon to sunset, where the Fraser meets the ocean, they went back to the sunrise and were never seen again. In addition to owls, there are also legends of other beings, sky-born people who carried special knowledge and also performed transformations. Many transformer features from both owls and the sky-born people remain today." Now, why should this be part of the facts of the case? I think it's important to understand the time depth that these people regard as having been with the salmon and the cedar and the rocks and the river and the trees, because it's important in what Dorothy Vanderpeet was doing as she set out that morning to take the fish that had been caught for her, I presume, and then exchange 10 fish for $50. In that transaction, she thought she was doing something that was a part of their long-term habitation, their long-term sustenance that they draw from these territories in being able to support themselves. But when she sold those 10 fish for $50, she was charged with violating the Fisheries Act, which required a license for this exchange, an Indian food fish license. And she didn't have that license. And the regulations say no person shall sell, barter, or offer to sell or barter any fish caught under the authority of an Indian food fish license. So she just had a food fish license. She's now doing something that maybe extends beyond food to a potential commercial purpose, and so this charge occurs. But she defends herself. She says, I'm doing this because I have an Aboriginal right to fish, exchange fish for money, engage in commercial practices around fishery, and because I have this Aboriginal right, it's now recognized and affirmed in Canada's Constitution. It's the highest law of the land. And therefore the local, the parliamentary regulations have to give way. They're of no force and effect, she argues, or her lawyers argue, because they're contrary to that long-standing Aboriginal right. And so that gives us the dispute here, gives rise to the question, is her right to fish for commercial purposes existing? Has it been extinguished? If it is existing and not extinguished, how can it be properly recognized and affirmed? The answer to the question is the court is going to find, by defining the Aboriginal rights to fish for, to exchange money for fish, by defining that as being necessary to their integral culture, the court's going to find they didn't possess a right to fish commercially prior to the arrival of Europeans. Actually, they didn't possess a right even to do something lesser than that, which is to exchange fish for goods or money. And because they didn't do that prior to the arrival of Europeans, they cannot claim that's an Aboriginal right today. Therefore, there's no reason to get into questions of extinguishment or justifying infringement, because this woman, the court says, does not even have that right.
So when you look at trading and the trading that happened from the coast to inland, is that not a commercial?
Yes, the court does not consider that the way the First Nations here dealt with the fishery was, at least in the Vanderpeet case, something that that they did that was distinctive, integral to their cultures. Now, with the Gladstone people, which we'll come to later with herring roe on kelp, the court is going to find that they do have a commercial right to fish in that context, take that herring roe on kelp, but in this context, they don't. Now, the challenge, looking at this historically, is multifaceted. One part of the challenge is that at the same period that contact was occurring here between the Stolo and other Aboriginal peoples and the Hudson's Bay Company, you have contact occurring in what's the Oregon Territory, which eventually becomes Oregon and Washington State. And there, Governor Stevens entered into a series of treaties with many of the tribes down there. And the main thing that each tribe negotiated for in securing the treaties, that he had to actually change the document that he was given, that he was sent out with the treaty negotiation, is they insisted on the right to fish and take up to half of the fisheries, to share the fisheries. The courts interpreted that as half of the fisheries that are available, which includes food, social, and ceremonial purposes, as well as commercial fisheries. So if you were a Stolo person that was just living across the border here in Washington State, and you were a party to one of those treaties entered into by Governor Stevens, you would be able to take 50% of the catch of fish that runs into your territory and use that for commercial purposes as well as food, social, and ceremonial purposes because of that agreement. And the ancestors of the Stolo living on this side of the border insisted on that. Another part of that challenge is that when Fort Langley was set up, one of the two Hudson's Bay posts, one was here at Fort Victoria, the other one was in Fort Langley, the Hudson's Bay traders struggled to be able to survive in those first couple of seasons, and it was through the provision of fisheries and other goods that the Aboriginal peoples had there that those people sustained themselves. In fact, Fort Langley became quite prosperous early on, not just so much through the fur trade, but actually through the salmon fishery. As the Stolo people traded salmon into Fort Langley, what eventually occurred is the Hudson's Bay Company sold those salmon as they were smoked and salted down to what was called the Sandwich Islands, which you might know as Hawaii. So salmon from this area, just after contact, started to go out in large, huge trading ships down to the South Pacific to be able to further support adventures that were taking place as the British were in that part of the world. But the court's going to say here that that all arose after contact. What happened with those treaties? Obviously treaties take place after contact. What happened with trading salmon down to Hawaii? That took place after contact. And the court is not willing to consider more broadly the commercial context of this culture, which, after all, remember, 2 months of work, the salmon comes into your territory, all this protein arrives. Then you have 10 months to be able to accumulate and provide further abundance. So what do you do in 10 months? Yes, you put up big houses and make coffers and tell stories and build beautiful intricate structures with clothing, with the cedar and hides that they have. And remember the Chinook jargon, the 300 words that you could trade up and down the coast from Alaska to Northern California. The court does not consider very prominently that aspect of this great maritime trading culture. They focus particularly just on the fish, and they draw the conclusion that they weren't doing this in any great numbers prior to the arrival of Europeans, and therefore you can't claim it as a right that's therefore recognized and affirmed through the Constitution. Okay. So the issue is, how should Aboriginal rights be defined here? How is it the case that the court arrived at this conclusion that Ms. Vanderpeet violated the law by selling these 10 fish for $50? And the court comes up with a test, and we're going to go through those 3 points now of looking at how Section 35(1) should be interpreted. And first of all, in paragraphs 15 to 21, the court says that Aboriginal rights are different from other rights that are the product of the liberal Enlightenment. They are saying here, quite rightly in one way, that Aboriginal rights are not charter rights. We spent a lot of time on that last class. Right? Aboriginal rights are in Part 2 of the Constitution Act 1982, not Part 1. They're not part of the Charter. And so the court says here, because these rights are not held by individuals, we can't look to the way we generally define rights to give us help in setting a test for Aboriginal rights. They have to be viewed differently, the court says, because they're only held by Aboriginal members of society. They say, as the academic commentators have noted, this is paragraph 19, Aboriginal rights inhere in the very meaning of aboriginality. So the court is going to have to, in their view, construct Aboriginal rights through the lens of what it might mean to be Aboriginal. And in fact, end of paragraph 17 has that point italicized. It must not be forgotten that the rights it recognizes and affirms are Aboriginal. Fair enough, at one level. But there's another level here, which is Section 35(1) says the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. I wonder why the court made such a big deal of the Aboriginal part of that without correlating that in relationship to peoples. If you took peoples as a focus here, you might have had a different construction of defining Aboriginal rights. Because I think what Aboriginals invites is an abstraction based on who knows what that creates an a priori view or vision of Aboriginality. Whereas if you correlate Section 35(1) by societies, protecting the rights of peoples has meaning in international law in a way that Aboriginals might not have. So I asked the questions here: why does the court talk about liberalism? What is the court's conclusions about liberalism? And then I also asked this provocative question, maybe, which is, how might even Aboriginal rights be themselves liberal? I want you to think about that for a second. Is the court right in creating this great gulf between charter rights and Aboriginal rights? I'll give you my start in the answer. If you have questions or comments to join, I would welcome them. But if you think about rights, extending way back to Magna Carta, what they're often about is constraining the sovereignty of the crown. So Magna Carta was issued 800 years ago to a few barons. It wasn't a very wide declaration of rights, but it said, Crown said to the barons, the landholders at that time, that we will not act to dispossess you of your landed rights in return for your loyalty that you would give to the crown. Then you get a lot of back and forth around that. It's not a straight line in the growth of rights. There's lots of erosion of rights, even from that diminished principle. But eventually you get something called the Glorious Revolution of England in the 1680s, where there was a sort of a huge civil war across the country, and as a part of this civil war, the monarch was eventually forced to recognize that he could not, or she could not, spend the money that was part of the realm that was often possessed by these barons, these nobles, these lords, without having a representative body in Parliament that accredits that or allows that to occur. In other words, the Glorious Revolution created something known as the English Bill of Rights. The English Bill of Rights is that the crown, the monarch, the sovereign, can only act through Parliament. Cannot spend money directly as the executive needs that kind of representation. Again, it's a small group of people that's being represented in Parliament, but nevertheless it's an expansion of that concept. You eventually get the American Revolution, and that is extended further as rights. Also the French Revolution does the same thing, which says to governments, not only do you need to act through an institution like a parliament or a congress, but when you act, here are particular rights that the sovereign, here are particular areas that the sovereign's actions cannot extend to. You can't quarter soldiers in the American Bill of Rights in private individuals' homes. You can't take people's property, individuals' property, without due process of law. You can't establish religion. You can't interfere with the exercise of religion. So in other words, the government's sovereignty is further constrained by these actions for individuals. You could now put Aboriginal rights in that trajectory and say, in fact, it is part of the liberal Enlightenment, because what Aboriginal rights do is they also constrain governments, but just in another way. Rather than, saying you have to go through Parliament, or you can't do something to an individual, a group of people, a society, a pre-existing society, when it encounters the crown, the monarch, can't be acted upon just with free rein. There has to be constraints in the way that the Crown acts in relationship to that society, just as the Crown is also constrained in acting in relationship to individuals, or the Crown is also constrained in acting through Parliament. So you could make an argument, I suggest, that Aboriginal rights are part, in one way, of the liberal Enlightenment because they are about constraints on Crown sovereignty. The court doesn't go down that path, but I think that's worth thinking about as you're parsing through future cases. If you ever practice in this area, it's also important to develop that gloss of the idea and show that what the court's eventually going to come to with reconciliation has this aspect embedded in it. Any questions, though, or comments on trying to run through these arguments around liberalism? Yes.
It seems like the decision focuses on not so much the constraint of the Crown's sovereignty, but the reason that the Crown is constraining its sovereignty. So whereas all people are created equal with certain inalienable rights is sort of the liberal thing that the Crown constrains itself for all people. They're saying the reason we're constraining ourselves in this way is because you have certain Aboriginal priority because you were here first. So I take your point, but I do see something different between the sort of larger liberal rights and Aboriginal rights.
Yes, because they're not doing this next point, which is construing liberalism for Aboriginal peoples in the largest liberal and generous way they possibly can. Like they're not taking that broader vision. They're focused on that point, which nevertheless is important and helps Aboriginal peoples here, but doesn't allow that expansive.
Yeah, just kind of on that same note, isn't by classifying Aboriginal rights as part of this history of, or this tradition of liberalism, doesn't that frame Aboriginal rights as contingent upon the state for their existence?
Okay, so the question is, if you frame Aboriginal rights in a liberal context, doesn't that potentially endanger Aboriginal rights because they become contingent on the state and its creation or its recognition? Well, that is a good question and can go either way. I think in much of the British parliamentary tradition, it is the idea that all rights flow from the Crown, and the Crown, if it wants to grant rights or wants to constrain itself, it's up to the Crown to be able to do that. There is another tradition, though, within liberalism that's picked up in the American context, which is rights that individuals hold, rights that groups hold, like religious groups hold, are inherent. They are inalienable, meaning they are given, as it says in the Declaration of Independence, they're given by a broader divine source. We can secularize that and say that it adheres in every person that you have a right to be free from being constrained with regard to your liberty, regardless of what the state has to say, regardless of whether or not that's contingent on the state. So there are two different views there, and I think we picked up in the Canadian context that narrower view of liberalism. Maybe the Charter of Rights and Freedoms at times, when it's interpreted, picks up the notion that we carry inherent rights with us as individuals, not to be interfered with by the state. Think of the Morgenthaler decision and Justice Wilson's formulation. That's a kind of almost an American way of going about it. You could take Aboriginal rights on that path as well, which is they're not contingent or dependent on the state. They're pre-existing, they're inherent, they are part of what vests in people because of the dignity, getting into this broader arguments under rights. Hopefully that's not too much of a detour for you, but the reason to put it out there is to have you think, as the court is trying to do, what are the source of these rights? Because the court is going to define Aboriginal rights based on its understanding of those sources. Now again, the court does say that interpreting these rights, I've already mentioned this on paragraphs 23 to 25, we have to give it a generous and liberal interpretation. The Crown has a fiduciary obligation in dealing with Aboriginal peoples. The honor of the Crown is at stake. If there's any ambiguity in defining Aboriginal rights, that ambiguity has to be exercised in favor of, or resolved in favor of the Aboriginal peoples. The court says, when looking at these generous canons of construction, you start to then understand the purpose of section 35(1). So I ask, what is the rationale for entrenching Aboriginal rights? The court says the rationale is that there's one simple fact. When Europeans arrived in North America, Aboriginal peoples were already here, living in communities on the land, and participating in distinctive cultures as they had done for centuries. That's paragraph 30. So one of the rationales is there's a recognition that people were here living in communities as they had done for centuries, and that the Crown came along and asserted sovereignty in relationship to this pre-existing group of peoples. And so the purpose, this is paragraph 31, is to acknowledge this distinctiveness that Aboriginal peoples have and have it be reconciled with the sovereignty of the Crown. Or, Aboriginal rights recognized and affirmed in section 35(1) must be directed towards the reconciliation of the pre-existence of Aboriginal societies with the sovereignty of the Crown. And the court backs up that point by looking at comparative law. They look at the U.S. cases that come from Justice Marshall, which we already saw quoted in the Siwi case. In the Siwi case, Justice Marshall says that the British policy was to recognize Aboriginal peoples as domestic dependent nations, that the British government did not interfere with their internal affairs, that they continued to control their own governance, but they received a limit, which is they could no longer deal with another nation other than the British Crown. They couldn't deal with the French anymore, they couldn't deal with the Spanish or the Russians or whoever else might come along. But the point of that case is U.S. jurisprudence recognizes that Aboriginal rights survive the assertion of Crown sovereignty, survive the assertion of the American government succeeding to the British Crown in south of the 49th parallel. The court also looks to the Mabo case in Australia and says the assertion of Crown sovereignty, the Crown's radical title, did not extinguish Aboriginal rights in that country either. And Mabo says, so where do Aboriginal rights come from? They come from the customs, the traditions, the practices, the laws of Native peoples. And what the common law does is try to reconcile those Aboriginal laws, practices, customs, and traditions with the Crown's assertion of sovereignty. And then we get to hear from both Mark Walters, a professor at Queen's University, and Brian Slattery, a professor at Osgoode Hall Law School, to give some framing to this reconciliation. On the bottom of page 122, this is in paragraph 42, the court quotes from Professor Walters. The challenge of defining Aboriginal rights stems from the fact that they are rights peculiar to the meeting of two vastly dissimilar legal cultures. Consequently, there will always be a question about which legal culture is to provide the vantage point from which rights are to be defined. Different cultures meeting with one another, whose perspective do you take in giving them meaning? We've already had an answer to that question in Sparrow. It's crucial that you give sensitivity to the Aboriginal perspective on the meaning of the rights at stake. In the first lecture, I talked about this Here's the end of the quote. A morally and politically defensible conception of Aboriginal rights will incorporate both legal perspectives. And then now Professor Slattery. He has suggested that Aboriginal rights is neither English nor Aboriginal in origin. It is a form of intersocietal law evolved from long-standing practices linking the various communities together. Two powerful quotes that set the framework for what the court should be doing in defining Aboriginal rights. This is all great on paper. But one wonders, where's the Stolo perspective in this decision? Where's the discussion of ALS? Where's the discussion of their transformers? Where's the discussion of their obligations as how they viewed commerce? The perspective that really is guiding here is kind of an anthropological perspective about the scale of the fishery in terms of trade at the moment of contact, rather than the broader idea. But there is a role for Indigenous law in defining rights, and the court, like, they're really plain about that. It's just too bad that application doesn't really get added much to that framework.
Do you think the failure of the court to kind of consider Aboriginal rights comes from, like, do you think it's kind of just a blind spot where they're like, the only way you can look at this is through an anthropological perspective, just because of the thinking at the time, or do they kind of like, do we see it and just decide not to?
Yeah, so what's the question is, what's the reason for failing to be able to understand or recognize that these perspectives, as they actually talk about in their cases, could underlie the law? One is, I don't think perhaps they've been around many Aboriginal communities to digest that perspective, and it's a very difficult thing in courts to be able to help when you've got a formal setting to have that sink in one way. Perhaps they've not had an opportunity to be in a course where they're continually introduced to the Aboriginal perspective on the meaning of the right at stake, or seeing Stolo law, as I tried to talk about at the beginning of this lecture, not just as evidence of what once happened on the land. That's often how it's received by the court, right? This stuff I've told you about the transformers, maybe that's evidence of their long time presence there, but this is an argument about going one layer deeper, which is there's actually standards for judgment that are embedded in that information. It's not just about establishing a time depth, it's also about establishing how you can best calibrate your relationships. Do you have a question?
Maybe, I guess.
Okay.
Doesn't the court tend to try and take the narrowest view of the issue if possible, so as to avoid setting precedents?
It does. So the question is, doesn't the court try to set the narrowest view possible so as to avoid setting precedent? And you could argue that is what they've done. Now, it cuts against what they said here with the canons: large, liberal, generous, ambiguities resolved in favor of the Indians. It also cuts against some of this stuff too, but it also requires the lawyers to do a different thing. So there's one part of your case when you're introducing evidence and you're telling through anthropologists or elders what their practice was in relationship to fisheries. That's kind of itself a challenge for the courts, as we'll look at when we come to the Delgamuukw decision, to even get that evidence in. But it requires a second part, which is when you then have your table of authorities that you present to the judge. Here's the law now that you need to judge this evidence by. It's not just citing Calder and St. Catherine and the Sparrow case. It's also saying, let me tell you the case of the bears that came down from Harrison Lake. Let me tell you what the legal principles are that flow from that case. Your job, judge, now is an intersocietal job. Your job is to take a morally and politically defensible conception that would incorporate both legal perspectives in judging this evidence. I don't know many lawyers that have done that, although I do know a few that have introduced evidence and then come and introduce law from that Aboriginal legal world.
Could you speak to your understanding of reconciliation here and what the court
Yes. So the question is, what is the meaning of reconciliation here? It's a very loaded term. What does the court mean by that? First of all, note that the court is calibrating reconciliation at the moment of contact. They're trying to ensure that this pre-existing society is not wiped out or erased or disregarded or whatever by the Crown's sovereignty. So that's the reconciliation at contact, that this society will continue to exist in relationship to the Crown's own society. But I've got a question here, which is, why make this past tense? Why make it at the moment of contact? Why make it at the moment, even as we'll see in the Delgamik case, of the assertion of sovereignty? Why not make it in 1982? That was the moment that the Constitution was promulgated in terms of its entrenchment. That would have a very different way of defining rights.
I just wanted to make a comment, and it's based on some work history that I did in the Yukon. And it was around the development of our administration of justice for the Teslin Tlingit Council. And that involved talking to elders. And for me, it was the first time that I had an awakening or an understanding of Tlingit law, Tlingit customary law. And because we were working in a modern self-government framework, you know, I often thought about how do you take that law and translate it to something in a modern context.
Yes.
And it kind of left me wondering whether we will ever bridge that gap, because our law is so embedded in a spiritual knowingness, I think, that it feels to me, unless you can understand that in a certain way, our concept of Indigenous, or what is law to us, may not be easily understood by mainstream culture. You know, and I wonder if we will ever bridge this gap.
Yeah. So the comment is, can this gap be bridged between Aboriginal law, which is there prior to the arrival of Europeans, and the way the common law operates? And there's a doubt as to whether or not that can occur, being expressed, because of the different formulation and source and experiential nature of those laws. And so that's a question that each of us would grapple with if we're in this field. It's a question that I grapple with. And yet the court has set itself with this task of reconciling Aboriginal laws with the common law, and having them intersocietally exist together. And that's what's morally and politically defensible. That's the way to proceed. But maybe it can't be done, and so it's another perhaps answer to your question. Why don't they apply this better? Maybe it's just not a failure of education or experience. Maybe there's an incommensurability that exists between those laws. Now, my point of view is that they are very different. And there are places that you just can't quite understand and translate across. Just like if we were speaking different languages from one another, or came from different cultures from one another. And so there's always something, even if you're a second language speaker of that language, you just maybe not ever quite grasp. But for me, it's not as dichotomous as that, because there's lots of places where I think there can be analogies worked, connections made. In fact, that's the work of the Indigenous Law Research Unit here at the University of Victoria that Val Napoleon is leading. And we're working with over 40 nations in Canada that are putting forward their laws in that way that seem to have some kind of possibility of understanding.
So that sort of issue be why the Truth and Reconciliation Commission recommended for law schools that have more mandatory Indigenous law training.
That's right.
And that go, we have like an entire, as you said, all these judges probably hadn't had like any familiarity with Indigenous law, customary law. So, I mean,
that's right.
It might not be totally bridgeable, but if everybody had it, or like, because it's right now it's very, very possible to complete law school in Canada and never bump into this.
Yeah. So there's a great comment / question, which is, isn't this why the Truth and Reconciliation Commission dealing with Indian residential schools recommended that law schools take up the teaching of Indigenous law so that we can either explore the incommensurability and understand the bounds and the limits of what the Canadian state can do, and or find points for connection. And maybe there's a bit of both. Maybe there's things that are just, will always be in different spheres, but maybe there's points where things can connect in spheres as well. So if you think about a diagram like this, it might be the case that there's aspects of Indigenous law that aren't understandable to the common law and vice versa, but there might be places where, you know, reconciliation could occur because law schools, lawyers, judges can find ways to do what the court is actually counseling here, which is to be large, liberal, and generous on this side, and then allow these streams to flow together in a pattern that changes us. And I think that would be exciting not only for Indigenous peoples, but for common law trained lawyers. Because now you would recognize some of the cultural contingency of the common law. If you saw the comparison that this goes on in a different way in another legal system.
I agree with that and the need for that, but I think, and potentially naively of me, I'm wondering, why is it a court's role to reconcile between two bodies of law that, I don't know, could get in the room together?
Yes.
And I mean, that's super naive, but I think even when I read these cases, it's super frustrating that that isn't a part of the creation of the Fisheries Act.
Yes.
And, I mean, it was 10 fish.
Yeah.
And I think there was a big part of me that was frustrated in that and what it would have looked like if that conversation could take place between, here's what we're trying to do, great, here's what we're trying to do.
Yeah.
And
So this.
I mean, I realize it's like the most naive and
Yeah, no, it's a
ideal
great
thing,
question. So the observation is the court the proper forum to be able to work out this kind of reconciliation, which takes us back to the last class. Remember, we wanted it to be international between British Crown and First Nations, with Canadian state not having a huge role there, just a kind of a fiduciary capacity. Then it was domesticated, and we tried to do that through constitutional conferences through 4 years, and the Meech Lake Accord and the Charlottetown Accord. We messed up there. So then we're sort of put into the courts as such a diminished place to be able to figure out the answer to these questions, because we didn't have the political will, power, imagination, creativity, whatever it is, to do that at the international sphere with those kind of forums, or to do it in the political first ministers to First Nations representatives, Métis, Inuit representatives. So here we now are in courts, and nice frameworks. I really applaud the framework here, but it's hard to work to that answer.
I was just thinking as you were speaking, that maybe part of the issue around that not happening is because of the Indian Act and the thinking behind the Indian Act is to eliminate our Indianness.
Yeah.
And so when you're eliminating someone's Indianness, and their laws are part of what make them Indian, you're not going to recognize it, because that would give the Indian, which is a legal term, more credence or more value.
Yeah. So this is a good comment, which is the role of the Indian Act in continuing to structure our law and our legal imagination about how this reconciliation might work out, because for the longest time the idea was to wipe out that circle, wipe out any distinctiveness there, and to the extent that Indians participated in Canada, it would be just in that sphere. If there is another vision of it, it's, well, if the Indians exist, they might be able to be delegated something from the Crown, but that delegation to Indian, Métis, Inuit group is dependent on, is contingent on, must have its values and laws flow from that other legal source. Now, this is not the Vanderpeek framework, but this is often the framework that continues to operate, well, it does operate under the Indian Act today. So what's the test then for defining Aboriginal rights as we're working this reconciliation? And in paragraphs 44 to 46 of the opinion, you learn that what's trying to be protected is what were those crucial elements of those pre-existing societies, or those practices, traditions, and customs that were central to these societies in North America prior to European contact. So the court at the bottom of page 46, or paragraph 46, says, in order to be an Aboriginal right, an activity must be an element of a practice, custom, or tradition integral to the distinctive culture of the Aboriginal group claiming the right. So this is Fort Langley. And you're looking for at that moment, just prior to Fort Langley being set up, what in the minds of Aboriginal peoples and the practices of Aboriginal peoples was so important that without that, they wouldn't be Stolo, or they wouldn't be who they were. This test then is given meaning by 10 further factors to be able to reveal what's integral to distinctive culture. So the idea that you have to take the Aboriginal perspective of Aboriginal peoples in defining what's integral to distinctive culture is set aside, beside, that it has to be cognizable in Canadian law, has to be understandable within the general legal system of Canada. Again, equal weight have to be placed on both. But what if Sheila's point is true, that some of these things aren't understandable, cognizable in the Canadian legal system? Does that mean you actually can't adequately define Aboriginal rights there? Court also says these rights have to be defined with precision. That is, you look at the nature of the action that Aboriginal peoples are engaged in, this time taking these 10 fish and exchanging them for money. The government regulation aimed at the control of commercial fishing for conservation purposes, and the tradition of the Aboriginal peoples themselves. Did they exchange fish for goods prior to the arrival of the Europeans? So you ask a very precise question. You also ask, again, about the centrality of this practice to the tradition. And at the end of paragraph 55, the court says, did it make the society what it was? Interesting wording, right? What you're trying to protect here is a once upon a time thing that was important to the society, not necessarily what's central, significant, and important to them today. Paragraph 59, a practical way of thinking about this problem is to ask whether without this practice, custom, or tradition, the culture in question would be fundamentally altered or other than what it is. So now we're to the present. Go back and forth between that. Then you have to find a continuity with pre-existing practices today. The court is generous and say it doesn't have to be an unbroken chain of continuity. Remember that colonial history I related to you? The Crown can't come along and say, well, we broke your chain of continuity, therefore you no longer have it. There is some room there for interpreting that more flexibly, this idea of continuity. But nevertheless, you still need continuity between what was there prior to contact, what's there today. Evidence has to be adapted. The laws of evidence, you might be in evidence this semester. The court should not undervalue the evidence presented by Aboriginal claimants if it doesn't conform precisely to the rules of the common law. Again, this right has to be pursued on a specific basis Each group has to prove that they have the right, for instance, to fish for commercial purposes. If the Gladstone Healthsick people get a commercial right to fish for herring roe and kelp, that doesn't mean the Haida can do that.
And that's really frustrating.
And that's frustrating. It doesn't mean the Tsimshian can do that. It doesn't mean the Niska can do that. The court says here that it has to be on a group-by-group basis, a case-by-case basis, because Aboriginal rights are not general and universal. They make the point. Yes?
So, it's just a question and my frustration. So when something is put out on us, it affects your nation, which is in Ontario, your nation, which is up in the north, and my nation, which is on the west coast. But when we have to prove things, we have to go and prove them as individual nations.
So this is a good observation. When laws are applied to us like the Indian Act, it's presumed that every Indian nation has to receive that burden. But if there's a victory that we get, that is a victory that can only be claimed by one nation. We can't presume it has that wider application. There's something troubling about that. Those rights can't be incidental, meaning they can't piggyback on other rights. They have to be independently significant in order to claim their place as an Aboriginal right. They, again, need to be distinctive to the people. It's not so much that it has to be, they're the only group in the world that does this. It's not a comparative process of distinctiveness. It's just how important it is to them. If something's developed as a result of European influence, you cannot claim that as an Aboriginal right. So just because the Stola started trading and were amazing traders in such great volume after the Europeans arrived, doesn't mean that they can claim that today.
How does Métis fit in that then?
So the court has to bracket Métis here, because obviously Métis people were formed after the arrival of Europeans. And so they'll eventually come to the Poway test to deal with that question, which is develop another test, which is not quite this test here. But another thing to say about this idea of European influence is this. Isn't it always integral to any distinctive culture to be able to adapt to the changes that come amongst you? If you can't do that as a culture, you die as a culture. So I think they actually miss the biggest point about what would be integral to any culture, which is its ability to be able to pick and choose and flow and have opportunity to receive or reject what comes amongst them. But this test doesn't allow that to occur, because if it is a result of another culture's influence, you cannot claim that protection as an Aboriginal right. And here, commercial rights, because of European influence, developed more strongly within the Stolo, therefore they can't claim that right. And so those are the factors that help with the definition.
Going back to the specificity example.
Yes.
How, like, you think going forward there'll be an opportunity to kind of like redefine the meaning of, or use the word group differently, because you've got the multi-meaning people.
Yes.
If you could argue that, like people who work outside arguing that it's been proved for one member of that group, but they're kind of like the group isn't just the tribe, it's also the larger group.
So this is a good question. It's a question about specificity and why we might only just focus on a band-by-band, case-by-case basis in proving or disproving these rights. Because it's not just the Stolo living in Chilliwack that are part of this broader cultural group, right? We're here on Vancouver Island with the Couch, and the Hulkaminam are here too. So there's room, perhaps, as you're suggesting in the future, to change the way we look at Aboriginal peoples. But the point is, the court's only looking at Aboriginal here, right? We're not really looking at peoples. We would have had a whole different discussion if instead of trying to define what Aboriginal means, we were trying to define what society means or peoples means. If we were trying to define what peoples means, we probably wouldn't be in this cul-de-sac of really, this opens itself up to stereotyping and cultural misreading, and it's obviously a past tense thing as well. Imagine someone coming along and saying, what's integral to the distinctive culture of your family or your culture or Canadians? We can't figure that out. Right? And part of what we do is this kind of development through time as well. I'm mindful I want to get through these other two cases, but I'll take a couple more questions.
Okay, I just want to make a point on people. I read somewhere, and not being a law student and not being a lawyer, but I read somewhere that the reason that they don't entertain people is because it opens up the rights that are given to First Nations people. It would open it up much wider, and that wasn't wanted to happen.
So this is a good comment, right? This test here, the distinctive unit and the integral distinctive culture test is a way of narrowing what might be available to Aboriginal peoples in the present day. If you focused on the society's element, the people's element, you were more generous, liberal in allowing that to survive, then we wouldn't just be talking about fish, we'd be talking about education and child welfare and governance and all these other things. It is now an extra hurdle. Remember the burdens of proof that I talked about at the beginning of the class? To establish an Aboriginal right now, Aboriginal peoples have to get all this historic evidence about what was once upon a time central to them that was not a part of European influence, that that has to correlate with these factors. And it's an extra burden. You could say it's a narrowing of section 35.1 of the Constitution. So we talked about the application here. It's not characterized as commercial because they didn't do this, in the court's view. I think that's questionable, even at that point. But they're saying they didn't do this in the way that they did after the Europeans arrived. So there's no right to exchange fish for money. Le Debate critiques the majority and says, I don't see the Aboriginal perspective in your application of this test. And making contact the cutoff date for the development of Aboriginal rights overstates the impact of European influence. It itself is a kind of a colonial imperial act that the court is replicating in the creation of this test. It crystallizes British sovereignty and creates an arbitrary date for asserting Aboriginal rights. And then Justice McLaughlin says, I'd look to Indigenous law, and I would see that Indigenous law continued to survive the assertion of European sovereignty, and these people, in accordance with their customs, practices, and traditions, traded fish, and therefore they should be able to trade fish. And then she would deal with this on the back end of the question. So what's the proper justification for infringement if there's an Aboriginal right to fish here? Which is then the Gladstone case. Gladstone, there's a trading of herring roe on kelp into a big warehouse. The fisheries officers are engaged in a sting operation. They've been watching the Celtic people do this. And so when they come out of the place where they're trying to sell this kelp, they're charged with selling it contrary to the license they held. It's not food fishery they're engaged in where they're putting this in for money. And the question then is, do the Celtic people have a right to exchange herring roe and kelp for money? And in this case, the court arrives at the conclusion that they do. Because prior to the arrival of Europeans, they did this up and down the coast. And Marvin Storrow, who argued the case on behalf of the Celtic, painted an image of the canoes being weighed down with the gunnels just close to the water as they went with the herring roe and kelp. And then when they came back, the gunnels were up because they were now free of this kelp and received other things of a different value. So they were able to meet the test that was integral to their distinctive culture. The court, though, says now they have a right that's defined and there's a prima facie infringement. What's the proper role for justifying an infringement of those rights? And the court says, in Sparrow, when there was a right to fish for food, social, and ceremonial purposes, there was an inherent limit on that right. There's only so much food that could be taken by the Musqueam to consumed for those purposes. But if it's a commercial fishery, that could just be, you could fish and fish and fish till you can never really satiate the market. So it would turn into an exclusive right to the fishery. And the court is not willing to regard Aboriginal peoples as having an exclusive right to the commercial fishery, which is interesting. We could talk more about that. We won't, but that's a lot to say there. But because there's no exclusive right that they're willing to calibrate to that, they say we need to vary up the priority as to how rights for commercial purposes would be put out. And so the court says that there are other compelling objectives which would allow Aboriginal rights to be limited. For example, we would look to the broader social, economic, and political communities. We would look beyond Aboriginal peoples to see how the exercise of an Aboriginal right to fish for commercial purposes would correlate with the broader societal interests there, and also the historic use and reliance of non-Aboriginal peoples on that fishery. So now you're getting a balancing test when you're dealing with commercial rights. How important is it to non-Aboriginal peoples balanced against the Aboriginal use there? And so you set up a priority based on that. Yes.
Kind of interesting when you look at how Aboriginal people's rights are frozen at the moment of contact, but settler rights aren't frozen at the moment of contact. Because if you look at settler rights as frozen at the moment of contact, would they really have, they'd have a right to trade for fish, but maybe they wouldn't have a right.
Yeah, and if they were frozen at the moment of contact, you would just have a little bit of South Vancouver Island and a little bit of the Fraser. Everything outside of that would not be allowed to develop after contact. So there's, again, another kind of inequality that creeps in by freezing Aboriginal rights at the moment of contact and allowing the Crown that opportunity to flexibly over time put its own points in. And part of that flexibility we need to talk about in the Delgamuukw case, and I need just to read this out. I think it's going to be the last thing we do. One of the further valid legislative objectives that's permitted is a very broad formulation. I'm on the bottom of page 143. In the wake of Gladstone, the range of legislative objectives that can justify the infringement of Aboriginal rights is fairly broad. Now down a few sentences. In my opinion, here are the things that allow the justification for infringement. The development of agriculture, forestry, mining, and hydroelectric power. The general economic development of the interior of British Columbia. Protection of the environment or endangered species. The building of infrastructure and the settlement of foreign populations to support those aims. These are the kind of objectives that are consistent with the purpose and in principle can justify the infringement of Aboriginal rights. Colonialism can justify the infringement of Aboriginal rights. You're allowed to develop beyond that point of contact as the Crown. Aboriginal peoples are not allowed to take that same point on. So where all the action's now going to happen, this really is the last comment, when the Crown is going to justify an infringement of Aboriginal rights, it's often no question that they have a valid legislative objective. The question is going to be, has the honor of the Crown been adequately protected in the way that that infringement is occurring? And that's what we're going to pick up next class, that question in greater detail. Thanks for your great discussion today.